So the draft of the Digital Data Protection Bill proposes to do away with 8.1J section of the RTI Act. Section 8.1 lays down the exceptions for the law, cases in which information may not be disclosed. So I'll just read out part J here, which says that information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual unless the Central Public Information Officer or the State Public Information Officer or the appellate authority, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. So, can you tell me like what this, section 8.1J, like what this part means? And what may happen if this amendment comes through and this part is done away with?
So it's not that the whole of 81J goes. In fact, what happens is that 81J will be amended so that it will go that information which relates to personal information, full stop. It will stop there. So any information relating to personal information will not be given. It will attract the protection of privacy because it's defining privacy. Now, defining privacy under the RTI Act has been done in 81J in a very effective and thoughtful manner. And it means reading and understanding the entire part of 81J, which is that relates to personal information, which kind of information, the disclosure of which has no relationship to any public activity or interest. So it's that personal information which has nothing to do with any public activity or interest. That information should not be disclosed, obviously, because why would one want anyone's information, whether personal or otherwise? Because it had some bearing on public activity or interest. So number one. Number two, or it's a second part, which would cause unwarranted invasion of the privacy of the individual. So obviously the privacy of the individual, if unwarranted, if it's warranted invasion of the privacy of the individual, meaning let us say that someone is storing some very poisonous gas in their factory or in their home or in their backyard. I'm just giving you an example, and you say, what are in those tanks? Now, normally, maybe it would not be warranted for you to ask what's in someone's tanks in the backyard. But if there is a possibility that it would have a bearing on public interest, then it is warranted. Or if there is something that you yourself are causing damage to people within that home, you don't have the right to cause damage to someone else working or walking in through your area or your home. I'm just giving you examples. So there are two particular scenarios. The first is that if it has a bearing on public activity or interest, then whether it is personal information or not, what is more important is the fact that it has a bearing, and therefore you can ask that. And the second is that if you are just trying to be a voyeur or you're trying to find out something that there is no reason to find out, then obviously the privacy of the individual is sacrosanct. And then there is a further part. Even if you are doing an unwarranted, seen as asking an unwarranted question on which has to do with the privacy of the individual, it says, unless the Central Public Information Officer, the State Public Information, or the Appellate Authority, as the case may be, any of those three, Central, State Public Information Officer, or the Appellate Authority, is satisfied that the larger public interest justifies the disclosure of such information. That even so, even if you have not been given at one level or the second level, even the appellate authority can say, yes, if it is justified, that information should be disclosed. And then there is that proviso, provided, and that's the last degree of filter, that provided what information cannot be denied to the parliament or the state legislature, meaning if they are to ask a question, and you cannot deny it to them, then you cannot deny it to the ordinary citizen. So there are multiple levels at which 81J protects privacy, and protects public interest. And it's not that you have to show public interest to begin with. It's obvious on the face of it. Let us say I'm in a dark zone and I'm digging a well that's going to completely reduce the water table for the whole village, and I'm not supposed to be doing so. Then obviously someone can ask, why are you digging? How deep is your well? How much water are you taking out of it? Because it is public, that water belongs to the people. So it's only through these examples that you can get to know, or what has been done, how much, who is drawing rations or who is drawing pensions. Are they justified in drawing it? Because there is a sort of finite amount and it's meant for particular segments of people. So even though if some very rich and affluent person who should not be drawing rations is drawing rations, or if they are getting under some state insurance scheme money that they should not be getting, or if someone is getting Narega wages when they are actually living in some city, all that is information that people should be able to ask about. Or if an affluent person or a landowner has more land than the Land Ceiling Act, I should be able to get that information because they are people who are affecting public interest and breaking the law.
Right. So, I mean, what do you think will happen if this amendment comes through?
Yeah. So even without the amendment, it was a disaster. Even without the amendment, in most cases, because government servants want to protect their own, if you ask for an inquiry report, if you ask for what's happened on a corruption allegation against someone, if you ask something else, or you ask even for property returns of public servants, which you have every right to ask, because obviously, where have they got their wealth? Is it justified or not? Those are all things that you should be able to ask. But you're put off by saying, no, this is private information that concerns only the individual. So in interpretation, but all along you have had 81J to say that no, this is the reason I want that information, and this information on the face of it has a lot to do with public activity or interest, and it's not an unwarranted thing that I am asking for. Now with this gone, and if you read it as just saying information that is personal information, cannot disclose any information that is personal in nature, information which relates to personal information, full stop, not qualifying it at all. Everything relates, almost not everything, but almost everything relates to some person, either an official or to the person doing something, or the person by omission or commission who's left out. So there is personal information. And there are enough protections in the RTI Act. 81J is a protection. It is to say that no, you just can't go and ask for anything. So if this comes, it is a disaster. It's almost the end of the RTI Act. And there's a whole section of the RTI Act which is proactive disclosure, which says you should put all the information you have out in the public domain so that people should not have to resort to the use of the Act. That's how much Section 4 says, and it names 17 things, including the names of officers, their designations, their salaries, where their budgets come from, what licenses they've given, who has been granted the licenses, etc., etc. All kinds of information. What goes into a policy, what's gone in their file notings, everything can be personal information. So it is almost like the death of the RTI Act. And then there is another part of this which says that this act will override the RTI Act and any other act. So if you override it, then obviously this is an act which has all kinds, even privacy activist says it actually doesn't protect privacy. So this whole DPB, the bill, is actually neither giving privacy nor really, and it's destroying transparency. So it's a doubly problematic thing, because along with most prominent privacy activists, 81J, the first thing that everyone said is that you should look at privacy through the lens of 81J, because it's a protection. 81J is a protection to privacy. It is a qualified, well thought out, well crafted protection to privacy. what you will end up doing is neither giving privacy nor allowing any form of probity or proper governance or proper ordering of society. And there was a committee, the first committee under the chairpersonship of Justice Shah to look at privacy, actually said privacy should be looked at through the lens of the RTI Act. Both of them must go together in harmony. This is the end of harmony.